Hello, this is Derek Green, and I'm going to be sharing a little bit about a case study that I done. It's going to be about, of course, the pop artist Katy Perry versus the gospel artist Flame in this suit filed against her. Now, the Christian rapper Flame did file suit against pop artist Katy Perry, saying that the pop elements of a eighth note ostinato or sequence of notes from his song Joy for Noise, and she took it and put it in her song Dark Horse featuring Juicy J. So that was the case filed. Now let's get into who Flame is. Flame is a Grammy-nominated hip hop artist from St. Louis, Missouri. He released about 9 albums. He has received several Dove and several Stellar Award nominations and have had multiple Billboard hits. He has started his own label imprint, Clear Sight Music, and it's basically a label dedicated to the niche market of Christian hip hop here. Okay, so the song she's suing for the song Dark Horse is going to be off her album Prism, and the success of that album was very successful. So it said that Perry made 3.2 million. Producer Martin earned 1.2 million. The other producer Circuit earns 826,000 off of the song. The co-writer Hudson earned 670,000, and Dr. Loof management received 347,000. All in all, said the Capitol Records earned about 31 million from the sales of the album and the single. Okay, so of course, being an artist, being a very popular artist too in your own genre, you release a song, some of your intellectual property gets used and it gets used and put on a success level that is even greater than your own usage. So, of course, you're going to want some type of compensation for this infringement, and that's why he went ahead and took him to court. Now, the jury awarded him 22.8 million in damages. A jury found in favor of the plaintiff, whose real name is Marcus Gray, by the way, and did find that Katy Perry was liable for the song and that it did infringe on his original music. So, of course, you can see the picture here. He's a happy guy. He just won, so he was on the up and up, feeling really happy about the decision and that his intellectual property was protected. But that didn't last too long because an appeals court did overturn the original verdict due to Katy Perry and her legal team. As you can see, this is a picture of her celebrating the overturned verdict. She always stated from the beginning that she didn't infringe. Of course, that she only used the basic elements of the song to build the foundation of the song, and the two songs had nothing to do with each other. They didn't never heard of artist Flame or any of his music. Um, so the U.S. District Attorney, they did go ahead and rule in favor of Katy Perry this time. U.S. District Judge Christina A. Snyder. She said that the notes of the individual elements that compromise the ostinato and joyful noise are independently protectable under copyright law. Basically, saying that he can't protect that because different producers use the same elements to kind of construct a sound, and it's all general. It's all for a general feel, and that's why those individual elements are not protected here. So of course, being a producer or being any type of creative, you want to keep your eyes and ears open on this case due to the fact, of course, we're all creatives, and that's why this is so important. But they did overturn, the judge overturned it after a jury listened and ruled in his favor. So basically, I don't really see any alternative dispute resolution going on here. It's like each side is going after each other. Once one loses, they're already going into the appeals court to try to get the ruling overturned. I mean, 2.8 million in the scope of things is not really a lot, and the money out of the 31 million that Capital made and all the other artists and producers made off the song. Um, he does feel like he is deserving of some compensation because they did use his original element, his original beat that he made from his song. Of course, him being a gospel artist and joyful noise, and Katy Perry being a pop artist, and Dark Horse, he went on to say this was kind of like an anti-Christianity thing, that they were just, the music industry was just targeting him, due to the fact he was trying to get compensated, from his original music, but they didn't want to pay that much money. Um, of course, the artist Flame and lawyer Michael A. Khan are planning to appeal this latest ruling. They believe that the initial ruling from the jury was correct, and they will try to get the original verdict put back in place in appeals court. They did say that this is going to be a win in appeals court due to the fact that they already appealed it and won. So it looks like, to be honest with you, everybody got different views on this. Of course, the original jury did rule in his favor, saying that they did infringe. Of course, they heard his song, then they heard her song, and they all kind of unanimously came up with that verdict that they did hear the same elements being used, just being used in a different way. Um, and they did feel like he was the original one who created it, so he should be the original one to be compensated for his work and his intellectual property. Of course, this case was important to the industry because it protected the creators from being sued for using basic sound and general sound composition and elements to build music. Of course, when you're building music, people do use loops. A lot of preordained sounds that just kind of build to each element. Like they were saying, if the blues song stayed on the same elements, we would just have the same blues song over and over again, which is understandable. Although things may be similar, they don't have to be exactly the same, and that's kind of what Katy Perry and her legal team was arguing, considering the fact that yes, the rhythm was similar, but it was used in different pitches, different bravado. So the elements were changed. Just being a producer myself, and knowing how music can be transformed, you can easily see that they could have heard the music, heard its rhythm, and transformed it to her particular song, to the beat and how they liked it. And that's what pretty much Flame and his legal team was arguing. So you can kind of see both sides of this arguments. But in the end, the latest ruling did stand that the music protected basically the general sound elements or the ostentato. Basically, you cannot copyright that because several producers use several different elements to build. As long as it's not exactly the same, then it's not really infringement. So we got the counter arguments going on right now. Of course, counter arguments are being a creative too, in the aspect of the artist Flame, having someone use your intellectual property and make revenue off of something which you created, without giving you proper notice or any type of compensation back after you receive, of course, all of this money from making it. Of course, the record was a huge success. It had, platinum rapper Juicy J on it as well. So just a huge success, and she went on and received several awards, and got a lot of money off of this record. But people are, of course, going to be anti, and the kind of arguments is the exact same reason ASCAP and BMI were developed, so you can't infringe on anybody's music or creativity. And that's kind of true in a sense, because that is exactly why these entities were formed, to protect people's intellectual property in the music, so people can't, take your beats or your production or your sound or your songs or your songwriting. These are $1 million entities that get paid, and people pay their of course their dues yearly to be a part of these organizations. And of course, when you pay these and you drop music legally the right way, you hope nobody does infringe on your elements. And of course, it looks like that that exact thing happened here. So you know the case is still going on. Of course, negotiation, if any, will of course have to continue in the appeals court and the appeals process. Like I said, it just seems like both sides are going straight towards each other. So I don't really see any mediation. They were trying to figure out the compensation for Flame, considering the fact the label made all this money, the producer made all this money, the artist made all this money. What is a fair compensation for him just because they used a little musical element? In the original court case, they were getting down to those proceedings and that mediation, and getting down to that a number they both sides could agree on. But of course, like I said, um, they went straight into appeals. Katy Perry's legal team and got the appeal, and then of course went on to win the appeal. So they came down to a settlement that he was. Going to get zero compensation. So of course it's going to go back into appeals court because his team is appealing it. So no one knows the true outcome of this case, but of course everybody is paying attention closely to this. Just like a similar case they were playing closer through with Pharrell Williams and Robin Thicke versus the Marvin Gaye estate, something kind of similar. So it's been kind of some legal precedences that have been going on with these kind of cases. But this one is the one that's currently going on right now, and you can kind of see both sides. Like I said, does he deserve compensation if they did use his creative aspect? And for creators who do this, and do and pay their dues for copyright, so no one can infringe upon you. Is this considered infringement? So can I take a eighth note ossiano or rhythm and use it like they happen to do in this song? Is that fair for the original creator who did make the original note sequence? All of that is still about to get displayed here in this next appeals hearing. Um, like I said, will he ever get compensation? Will he? Is he entitled to any compensation, if any? The original jury believed so. They believed that he was infringed upon. It was a particular judge who overturned that. So obviously we got decisions going in both ways. That's why this case is particularly interesting. Just to see the outcome on both sides of the aspects. So of course, only the future will see, and we will just keep our ears and eyes peeled on this particular case study. This has been Derek Green. I appreciate your time and listening to me, and thank you.